Good evening, everyone, and welcome to our final BicTok session for the year, session 37, titled Review of the 2025 Arbitration Case Law and Developments in Malaysia. My name is Michelle, and I'll be your host for today's session. Before we begin, let me lay down some housekeeping matters. Firstly, kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, issue your certificate of participation as well as for your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions during the Q&A session at the end. To guide today's discussion, we are honored to have with us our moderator, Mr. Tan Ki Heng. Mr. Tan Ki Heng, a council member for BicTok, is the managing partner of SK Ling and Tan Advocates in Kuching, with over 27 years of active legal practice. His experience spans banking and financial services litigation, corporate insolvency, company disputes, contract, land law, construction law, arbitration, as well as appellate advocacy. In 2024, he was appointed to the Pro Tem Committee for the AIAC Court of Arbitration, and he also became a commission member of the Companies Commission of Malaysia. We are truly privileged to have him moderating today's session. We are equally delighted to welcome our two distinguished panelists. Firstly, Mr. Kuhendran. Mr. Kuhendran is the head of the Construction Dispute Resolution Practice Group at Zul Rafiq & Partners. He is a fellow of the Chartered Institute of Arbitrators. His work spans complex construction and engineering disputes, arbitration, advisory work, and the drafting and vetting of major construction and engineering related contracts. Last but not least, we have Ms. Christine Lay. Ms. Christine is a partner at Abang & Co., a boutique firm focusing on commercial, construction, corporate, and energy-related matters. She specializes in commercial and corporate litigation and both domestic and international arbitration. She currently serves as a General Director of the International Women's Insolvency and Restructuring Confederation Malaysia. So without further ado, I will pass on the floor to Mr. Tan Ki Heng.
Thank you, Michelle. Good evening, everyone. Thank you for joining us this unique BicTok session under the leadership of Mr. Haban Singh, Council Member of the BicTok. This is the one and only kind available in Malaysia. Joining us this evening are our esteemed panel comprising Mr. Kuhendran and Ms. Kirsten, who will guide us through a handful of 2025 arbitration cases in Malaysia and providing an insightful update to all of us on the case law developments in the arbitration proceedings. Now, I am not sure how many of you would agree with me to say that updating ourselves with the latest development in the law is indeed the second nature of whoever in the legal practice, regardless of how junior or senior we are. Now, today, our two esteemed speakers will guide us through accelerated cases from the Court of Appeal and the Federal Court reported in 2025, which I divided them into few topics for them to highlight to us, such as on distinctive statutes in relation to arbitration, immunity of AIAC from judicial review proceedings, arbitration agreements, party autonomy, arbitrators' powers and duty, and finally, on the topic of setting aside an arbitral award on the ground of the breach of the rules of natural justice. Now, without further ado, I would like to invite Ms. Christine to highlight to us the first case first. Now, this is ING Bank on the distinctive statutes in respect of enforcement of a foreign arbitral award in Malaysia. Christine, over to you, Christine.
Thank you, Mr. Tan. All right, let's jump straight into it. We will be looking at, myself at least, will be looking at topic 1 and 2, and you've seen, as can be seen on the screen. So under topic 1, distinctive statutes, and we'll be covering 2 areas. First one being the interplay between Reciprocal Enforcement of Judgment Act 1958, the REJA, as with Arbitration Act. And secondly, we will be looking at interplay between Companies Act 2016 with the Arbitration Act. And moving on to the second topic, we will be exploring the immunity of arbitration or CIPAM-related matters from judicial review. Without further ado, let's go on to the next slide. Now, the first case that I will be discussing today will be the case of ING Bank. It is to highlight and discuss about the interplay or overlap between the REJA statutory regime as well as the Arbitration Act. Now, before we go into the factual background of this particular matter, let's take a step back and I'll give you a bit of information about what REJA is essentially, just as a brief recap. Well, REJA is a specific statute enacted to provide a mechanism for the enforcement of foreign judgments in Malaysia without the need to commence a fresh action, provided that the judgment originates from reciprocating country. Currently, there are 7 reciprocating countries under REJA, as recognized in Malaysia. We have the UK, Hong Kong, Singapore, New Zealand, Sri Lanka, India, as well as Brunei. Now, let's take a look at the brief background in relation to this particular matter, and I will quickly bring you to the different proceedings that took place, as these are all relevant leading up to the proceedings before our apex court in the ING Bank matter. The respondent in this matter is a Johor-based supplier of marine bunker fuels. The dispute stems from the appellant's claim that the respondent owed payment for the supply of marine bunker fuels under 2 supply contracts. Now, pursuant to the arbitration clause in the contract, the appellant commenced arbitration proceedings against the respondent under the London Maritime Arbitrators Association rules of arbitrator in respect of the sum owed. Then the London Tribunal found in favor of the appellant both in jurisdiction as well as in merits. So essentially, the respondent dismissed the respondent's challenge on jurisdiction. At this particular point, it is important that to note that the respondent did not comply with the award. The respondent also did not apply to set aside the award, nor did the respondent challenge the award under the UK's Arbitration Act. Now, what the appellant then did was apply to the English High Court for leave to enforce the London award. Similarly, at this point, the respondent did not contest the application. Therefore, in December 2020, the English High Court entered judgment in terms of the London award. Now, this is where proceedings then moved to the Malaysia court. The appellant applied to the Malaysia High Court to register the English High Court judgment in Malaysia under REJA and successfully obtained an ex parte order. This is where the respondent started responding. Firstly, the respondent applied to set aside the Malaysia ex parte High Court order on the grounds of lack of jurisdiction, fraud, contravention of public policy, and non-compliance with service requirement. And if you could look at the next slide, this is where the REJA proceedings are stated there. And secondly, concurrent to the REJA proceedings, the respondent also filed for an application for trial before the Malaysia High Court. The High Court dismissed the application for trial on the grounds that the application was an abuse of court process, in that it was an attempt to prolong the determination of the setting aside application by the court and to procure a decision of the Malaysia court, which may be inconsistent with the award that has been issued by the London Tribunal. So at this stage, the respondent clearly dissatisfied with the decision, appealed to the Court of Appeal. Next slide, please. And this is where we will see the Court of Appeal allow the respondent's appeal and overturn the High Court's decision for these reasons. But for today's purposes, next slide, please. I would like to focus on the Federal Court's decision. So essentially, the Federal Court allowed the appeal and set aside the Court of Appeal's decision. Under its decision, the Federal Court addressed the following 5 issues, as you can see from your screen, which are all in respect of the enforcement of foreign arbitral awards in the form of confirmation judgment issued by the seat court of a reciprocating country identified under REJA. And if I could quickly read out issue 1, that was addressed by the Federal Court, whether the winning party in an arbitral award is entitled to an enforcement of an international arbitral award which has been registered in the foreign jurisdiction in which the award was handed down under REJA and/or the Arbitration Act, or is it restricted to enforce the fruits of its arbitration only under the Arbitration Act? Now, in essence, the Federal Court considered the legislative background and the policy reasonings behind the Arbitration Act as well as the REJA, and the court found that the definition of judgment under Section 2 of REJA does indeed include an arbitral award, registered in the seat court as a judgment, and the principles of reciprocity in REJA. Therefore, it gives rise to an independent mode of recognizing arbitration awards in Malaysia. The court also recognizes that Arbitration Act is another mode of registration and enforcement of foreign arbitral award, which is direct in nature. Therefore, the conclusion being there are two discrete avenues for award holders to proceed with enforcement. Let's take issue 2 and issue 3 together, which is what the Federal Court has did as well. Under issue 2 and issue 3, essentially the court explored the question of whether REJA displaces the Arbitration Act. As we have covered earlier, we have established that both REJA and Arbitration Act are two distinct avenues for enforcement of an arbitral award. So the Federal Court found that the REJA is not displaced. Being distinct statutes, there is neither conflict nor inconsistency. And more importantly, the Federal Court highlighted this. To compel a reading or construction of REJA to align with that of Arbitration Act would amount to importing a specific provision and legislative intent of the Arbitration Act premised on the model law into REJA. The special relationship between the Schedule 1 countries, i.e. the reciprocating country, would then become subject to policy consideration that was considered in a different statute, which is the Arbitration Act. So the rules of less specialist does not even come into play in this particular facts of the matter, as there's no general law for enforcement of arbitral award which conflicts with a specific law for similar enforcement. So the takeaway of this is this. REJA and Arbitration Act are two distinct statutory provisions, and to that end, it will be incorrect to even compare the modes of enforcement, as it would not be a comparison of less generalist or less specialist. And I think with that, I will stop at this point in time, Mr. Tan, in respect of the ING Bank case.
Yes, Michelle. Christine. Based on what you analyzed to us, this case on REJA, not Rojak, on REJA and the Arbitration Act. Now, I have two questions for you. Now, follow from this decision where the Federal Court propounded. Now, it says the REJA and the Arbitration Act operate as separate and independent enforcement regimes. Now, can you please tell us how this decision affect the enforcement of foreign awards in practice in Malaysia? And do parties now have more flexibility or more complexity? That's my first question. And my second question to you is that, do you think that this decision opened the door to a potential forum shopping between REJA and the Arbitration Act for the purpose of enforcement of a foreign arbitral award in Malaysia?
All right.
Christine, yeah.
Thank you, Mr. Tan. I think those are definitely very practical questions, and I believe a lot of the audience perhaps will also be thinking, what then is the practical takeaway of this decision in ING Bank, and how would that apply from a practical perspective? Well, firstly, to take on your first question, do parties now have more flexibility, or does it become more complicated now to enforce your arbitration award? bearing in mind that it has to be a foreign arbitration award that has been affirmed or confirmed by a reciprocating country. So that is the context of REJA. Well, Mr. Tan, from my point of view, a short answer is no. Enforcement does not become more complicated. In fact, Mr. Tan, I believe it is a much welcome clarification between the interplay between REJA and Arbitration Act. If you recall, at the very early on, I mentioned that this is a overlap, or rather, how the regime of REJA and Arbitration Act, two separate and distinct statute, interact with each other. And both statute deals with the enforcement of foreign confirmation judgment stemming from a foreign arbitral award. This particular case have simply clarified that successful award creditors have a legitimate choice of remedies and may elect to enforce arbitral awards under REJA via a confirmation judgment without being considered judgment laundering. And I think that brings us to the second question earlier, where you asked, would this appear as judgment laundering? So again, the answer would still be a no. Bearing in mind that both exist as two distinct avenues and parties now may elect. So this also that embodies the doctrine of election as we are familiar with in legal principles. So I believe the important takeaway from a practical perspective is this. This judgment underscores that award creditors have flexibility and it very much depends on their recovery strategies against award debtors. And from a bigger policy picture point of view, I would say the takeaway is this. This judgment positions Malaysia as a jurisdiction that respects both treaty-based as well as reciprocity-based enforcement mechanism. So reinforcing Malaysia in its position as a reliable and arbitration-friendly jurisdiction as well. So I believe it's definitely a welcome clarification, and it does not make enforcement of award more complicated. In fact, parties now may elect, which is more helpful given the factual metrics of the matter.
Thank you, Christine. Thank you for the well-analyzed answer. And then thank you, but I will take it as a free legal advice. Next, we move on to another case concerning two distinctive statutes, the Companies Act 2016 and the Arbitration Act 2015. Now, Ms. Christine, can you please enlighten us on the legal principles provided by the Federal Court in V Medical Services, also this year's decision, in relation to an issuance of a statutory notice for payment under Section 465 of the Companies Act, and on the debt which is arguably disputed, and such debt falls within the ambit of the arbitration agreement concern. Over to you, Christine, on the V Medical Services case.
Okay, now on to the next interesting and overlap between statutory regimes. And I must say this particular topic is something that I am passionate about, both the interplay between insolvency as well as arbitration. And it's an overlap that is often discussed, especially in the insolvency space as well. So in fact, even in this case that we will be discussing shortly, the V Medical Services case by the Federal Court, Justice Nalini has in fact in paragraph 1 of the judgment itself has said this: the evolution and expansion of commercial arbitration globally has brought to the fore conflicts between arbitration and other areas of law. So what we will be exploring in this part of the session today is the overlap between Companies Act, which is insolvency, as well as Arbitration Act. Now, the interplay essentially is this. At the core of it, we are all familiar that arbitration is a regime that focuses on party autonomy as well as individual right. As opposed to, in an insolvency regime, winding up proceedings included, is collective in nature. So it prioritizes the interests of classes of creditors as opposed to a single creditor or a single stakeholder. So before we go into the case of V Medical, bear in mind that the interplay is this. And I often use the word interplay as opposed to insolvency versus arbitration situation, because by the end of it, you will come to, or in fact, even the federal court would say that both regime can exist hand in hand, and one does not put the other in any disadvantaged position. Now, let's look at the factual metrics of this particular matter, medical services. Well, the crux of the dispute between the parties concern a claim by the respondent that the appellant owed it a debt in the sum of about 158 million USD from the sales of 2 medical devices. The appellant challenged the debt on the basis that the devices provided were for promotional purposes only, and they did not buy those medical devices. So when the payment was not forthcoming, the appellant then initiated an arbitration proceeding. Under the arbitration clause in this particular matter, the arbitration agreement provided that the arbitration was to be held in Zurich, Switzerland, in accordance with the Swiss rules of international arbitration. On sometime in March 2022, the respondent served a statutory notice of demand on the appellant. So in response, the appellant then very quickly filed an application for a forcible injunction in the Malaysia court against the respondent. So bearing in mind, this particular matter, the background is of preemptive in nature. So there's no winding up proceeding have started, but the appellant has filed a forcible injunction, essentially to stop the respondent from taking on any insolvency proceedings. Let's look at, yes. So then essentially when the matters went before the court, the High Court, the Court of Appeal, and subsequently the Federal Court, before we look at the decisions of the courts, I would like to highlight the two tests that are discussed in depth by all the courts in this particular matter. We have the Salford test, which is also referred to as a lower threshold, versus the Sean participation test, which is referred to as the higher threshold. So what does the case say? Well, in the Salford lower threshold case, it states that a court should exercise its discretion to stay or dismiss a petition where there is a prima facie dispute as to the debt that is subject to resolution via arbitration. It is sufficient that the debt, which is the subject matter of the arbitration, is basically disputed. So, long and short of it essentially is this: what happens, what is the treatment of particular matter if the debt is subject to an arbitration agreement? Does that mean the court will automatically stay the matter and say, parties, please proceed to arbitration? Or will the court consider the particular matter? So now we've understand what is lower threshold Salford test. Let's look at Sean participation test. Sean participation, brief background, is actually a Privy Council case from 2024. And Sean participation essentially says that the existence of an arbitration clause in itself does not interfere with the threshold test applied in the winding up regime. So in the winding up regime, the test is this: a debt which is genuinely disputed on substantial grounds is sufficient basis for the grant of a forcible or restraining injunction or to stay and dismiss of a winding up petition. So I would like everyone to put a pin on the phrase genuinely disputed on substantial ground. That is the important keyword that will recur in throughout, especially the federal court, and that is the position of law currently in Malaysia. Now, let's go through very quickly what are the decisions of the courts in this matter. In the High Court granted the injunction because the High Court applied the lower threshold test that is pronounced in Salford. So in essence, by applying the lower threshold case, the High Court held that it was not incumbent upon the court to investigate whether or not the debt was bona fide disputed on substantial grounds, and parties must adhere to their arbitration agreement and proceed to arbitration. However, in the Court of Appeal reversed that decision and set aside the injunction. The Court of Appeal was of the view that we should apply the Sean participation test, which is the higher threshold, and you must consider whether the debt in question, which is subject to an arbitration agreement, is genuinely disputed on substantial ground. So, in other words, the court will look into whether the debt was disputed on a good faith basis. And subsequently, in federal court, again, the federal court unanimously allowed the appeal and found that the company had shown a genuine dispute of the debt on substantial grounds, reinstating the Fortuna injunction granted by the High Court and considered this particular main issue. What should be the test? And again, of course, I've said that a spoiler that the current position of the law in Malaysia is a Sean participation case. And the reasoning as adopted by our Malaysia Federal Court is this. It's because the test, the higher threshold test, is the correct approach to be adopted in Malaysia, as it clarifies that the law, while giving independent consideration to both the arbitration and insolvency regime, it will not conflict with each other. So the next question for us to ponder would be this. And I'm sure most of us are aware that Section 10 of the Arbitration Act, our Malaysia Arbitration Act, covers stay of proceeding when there's arbitration, stay of a particular proceeding in light of arbitration. And the question is this: whether that particular Section 10 covers winding up proceedings in Malaysia. To be more exact, let's consider when a winding up petition is brought in the company's court on the grounds that a debtor is deemed insolvent under the Companies Act. Is the company's court adjudicating on a matter which is subject to arbitration agreement? Because those are the wordings in Section 10 of our Arbitration Act. The short answer is no. The federal court in B Medical has said that the company's court, in determining whether or not the debtor is insolvent, is to put in place, or rather put into effect, the collective and cooperative system, to which will become the basis for an orderly distribution of assets to the creditors according to their entitlement on a pari passu principle. The company's court in general is not determining whether or not, the liability of parties in the matter or the merits of the matter, which will, if need be, if it's genuinely disputed, would be subject of consideration in arbitration proceedings. So with that, there is simply, again, similar to what we talked about in Reja, there's no conflict between these two particular regime, insolvency regime as well as arbitration. In fact, both can exist simultaneously, and if used properly, it will be able to balance depending on the demand of a particular case.
Okay, Christine,
Yes.
crystal clear on this case. No question for you here. I'm going to ask you to invite you to highlight to us the third case on the immunity of an arbitral institution from judicial review. Now, following from the leading case of Sundararaju 2021 by Federal Court, we are all very clear about the immunity conferred on the AISC from both civil and criminal proceedings in the respect of arbitration proceedings. Now, it is also clear that this immunity covers on acts and decisions made by AISC under CIPA. Now, then may I add on to say there are two relevant statutory provisions in the respect of the immunity conferred on AISC for proceedings under the Arbitration and CIPA. Now, Section 48 of the Arbitration Act 2005 provides that any person or institution designated or requested by the parties. Now, may I add on to say this may include BICM, Ansari David and Mr. Hamans from BICM who are joining us here also. We are safe as BICM council members. To appoint and nominate an arbitrator shall not be liable for anything done or omitted in the discharge of the function unless the act or omission is shown to have been in bad faith. So this is what Section 48 conferred on any institution designated or requested by the parties to appoint or nominate arbitrator. And next, on Section 34 on the CPA, then it provides that no action or suit shall be instituted or maintained in any court against an adjudicator or the AIAC or its officer. This is specific to AIAC or its officer for any act or omission done in good faith in the performance of his or its functions under this CPA. Now, Ms. Christine, can you please highlight to us the salient principle held by this recent decision of the Federal Court in AIAC versus One American residents? Over to you, Christine.
Thank you, Mr. Tan. Now let's go back to the slide that we have here. I think in the interest of time, I will not bore everybody with the facts of the matter. I think let's go straight into the principles that has been enunciated in this particular matter. Next slide, please. Let's look at the next page of the slide. Next one again. Now let's look at this. What are the issues that were considered by the Federal Court in this particular matter? So the first issue would be, what is the extent of immunity enjoyed by the AIAC pursuant to the IOPIA, and whether it applies in judicial review proceedings in relation to CIPA. So bearing in mind that Mr. Tan has very concisely and adequately provided to us earlier what is the current position of law in Malaysia. So bearing that background in mind, let's look at the first issue of what is the extent of immunity by AIAC in judicial review proceedings in relation to CIPA. So firstly, I would like to talk about the scope of immunity conferred on AIAC. Well, Section 4, the Federal Court looked at Section 4 and Section 11 sub 5, as well as the first schedule of the IOPIA, as well as the KLRCA regulation, the predecessor of host country, and the AALCO, the Asian African Legal Consultative Organization, and the government of Malaysia. And the Federal Court held that if the AIAC enjoys legal personality only to the extent required to perform its function, it is legally unable to act beyond its functional personality. Thus, any act not covered by such a limited personality are ultra vires. So that the Federal Court led to the next step of the statutory adjudication function of AIAC. Of course, the Federal Court pointed out that it was clear the 1981 Host Country Agreement could not have set out the AIAC's function on statutory adjudication, as the CIPA was only enacted more than 3 decades later. Hence, the Federal Court took a logical perspective that the agreement the agreement of the AIAC is with broad and general function, which are to be interpreted and reinterpreted as the international landscape evolves in the ADR space. Now, the Federal Court found that the host country agreement is not a static document, but one that must be construed dynamically. There's a need for broad and flexible method of construction. The Federal Court observed that the AIAC has since grown to become an arbitral institution to a full-fledged ADR hub of global repute. Thus, the Federal Court held that to restrict the immunity under the IOPIA to the AIAC's capacity as an international arbitral institution alone is not enough, taking into consideration that now AIAC performs other functions as well, including adjudication, as well as domain name dispute resolution services. Therefore, the Federal Court held that such immunity that's afforded to AIAC under the arbitration space also then extends to its other functions. Therefore, the function of AIAC as statutory education authority is also covered by the immunity that is afforded under the Act, the IOPIA. Now, the next question is this: whether the Act and the decision of the AIAC was ultra vires in this particular matter. Well, based on the findings, the Federal Court held that AIAC enjoys immunity in the exercise of its statutory adjudication function only to the extent if AIAC acted within the framework of SIPA. So any act or decision of the AIAC which contravenes with SIPA will be, in fact, ultra vires, in which case then the immunity will not cover such situation. So in other words, immunity is not obsolete. After scrutinizing the grounds underlying judicial review, Federal Court found that there was no merit in this particular matter, the One American matter. There was no merit in One American's contentions that the AIC had acted beyond its power and functions that is afforded under SIPA. So on the facts of this particular matter, it was found that AIAC did not action was not ultra vires. The fourth question, yes, Mr. Tan.
Yeah. You proceed. But I just have one question for you later on.
Yes, just very briefly, I'll just cover a bit more.
Yeah.
Whether the immunity extends to the judicial review proceeding, the Federal Court found that because it is not judicial review, it's not spelled out, it's not expressly mentioned in the wordings of IOPIA, but the wording says, in the Act says, immunity of the organization from suit and other legal processes. Therefore, this has been construed to also include judicial review. Because again, the Federal Court has considered the case of Sundar Raju back from 2021. And since in that case, in the case of Sundar Raju, legal process has been interpreted to include criminal proceedings. So therefore, by applying that principle to our case here in One American, surely legal process of IOPIA will also include judicial review. And with that, Mr. Tan, if you could give me that burning question, the burning question.
Yeah, Christine. No burning, but just that based on your what you highlight to us. That's one questions to you. Last questions to you before I temporarily let you off and then move on to Mr. Kohendran. Is that on this case that you just highlighted to us, the grant of such immunity, though not absolute immunity, is to ensure the independence of the organization in the exercise of its functions. Now, I want to ask your personal view. Now, do you think this immunity, which extends to the decisions made under SIPA, risk insulating the AISC too much overpowered, or is it essential for institutional independence and for maintaining neutrality and independence? What is your view? I mean,
well, Mr. Tan, I believe it's the latter, maintaining neutrality and independence. In fact, I think the decision of the Federal Court ought to have instilled greater confidence in AIAC's ability, or rather any arbitration institution's ability to carry out the vital role of its statutory adjudication authority under this SIPA. And this is some more than a decade after the SIPA was first introduced and came into effect in Malaysia. So this decision, I believe, should also encourage more parties to pursue payment claims under SIPA, especially given its relative speed. Well, I think some people may have something to say about the speed of SIPA nowadays, but essentially, big picture, I believe that this particular case will or ought to instill greater confidence in AIAC. Therefore, coming back to your question, it would maintain neutrality and independence. I think also just one more point to make from a policy perspective. I also think that the decision of the Federal Court demonstrates the court's willingness to consider domestic legislation within the context of Malaysia's obligation under international law. Especially given this year, our country is the host country for the ASEAN conferences. We saw how the success of the ASEAN conference, especially in our ASEAN region. So I believe all this is definitely looking good for the country and much welcome evolution. Yes. Back to you, Mr. Tan.
Thank you so much, Christine. I absolutely agree with you. For sure, BICM is protected also in the system. Now we are going to invite Mr. Kohendran to enlighten us on 5 recent cases covering arbitration agreements, the arbitrator's power and duties, and setting aside an award on the ground of the breach of the rules of the natural justice. Now, first on the arbitration agreement. Now, based on the Mr. Kohendran, based on the recent decision of the Court of Appeal in Setia 1, now I would like to invite you to enlighten us on when the arbitration clause provides that in the event of a dispute, either party may elect to proceed with either court proceedings or arbitration, but in that arbitration clause, it doesn't specify the seat of arbitration, the number of arbitrators, and the mode of appointment. Now, please enlighten us, Mr. Kohendran, based on this case. Would that affect the right of one party thereof who intends to proceed with arbitration? Over to you, Mr. Kohendran, on the case of
Mr. Tan, thank you. Maybe I will share the screen with my presentation and then go straight on with the answer to that question. I hope you all can see it. Just give me a minute. Okay, can you see this?
Yes.
Right. So, as Mr. Tan said, I'll be dealing with this Setia 1 first, but I'm also going on to other three cases about arbitration spouse, etc. But in terms of Setia 1, just before I answer the question, the facts there were quite straightforward. There was an agreement for Durham project in Setia 1. The disputes arose between parties. The SPNB chose litigation and filed a suit. SAM applied for a stay. Now the clause says any disputes may be referred to any court in Malaysia or to arbitration. The High Court dismissed the stay. The High Court said that the clause was invalid and it was missing those key components which Mr. Tan mentioned, and such as the seat, number of arbitrators, and the mode of appointment. The High Court also said that the giving parties an option to proceed litigation and arbitration is not a binding arbitration agreement. Now, the key issues which the Court of Appeal were faced in this matter when it went up was whether there was an arbitration agreement, whether giving an option of either going to court or arbitration renders the arbitration agreement null and void, inoperative or incapable of being performed, and whether the tribunal is tasked to rule on whether the tribunal or the court is tasked to rule on the validity of the arbitration agreement. Now, the Court of Appeal allowed the appeal and granted a stay. The Court of Appeal said that the arbitration agreement doesn't require parties to agree upfront all these components because there are default provisions in Section 12, 13, and 22 of the Arbitration Act. So, because of those default provisions, you don't need to agree upfront to the seat, the number of arbitrators, and the mode and manner of appointment. And then on the issue of whether or not you're going to go to court or to arbitration, and whether or not such an agreement is an arbitration agreement, the Court of Appeal said there is an arbitration agreement once either party elects arbitration, and also that an arbitration agreement giving parties an option is a valid arbitration agreement once that party has opted for arbitration. The agreement is not null and void or inoperative, etc. Now, the key takeaway from this case is that the court wants to keep a flexible approach on who is to decide the validity of the arbitration agreement, court or tribunal, depending on the facts of the case. This is not the key takeaway. The key takeaway is that in terms of who is to rule on the validity of the arbitration agreement, the court keeps a flexible approach. Now, the key takeaway, actually, I was going to say, is that based on the manner in which the Court of Appeal ruled in this case, it's quite clear that the court's policy is that they lean in favor of arbitration, as I stated in item 4. So that's basically in a nutshell Setia R1 management and SPNB aspiracy.
Thank you,
Yeah.
Mr. Kendra. Thank you so much for highlighting to us the salient points extracted from this case and the key takeaways. I have no questions for you on this case for the moment.
Okay.
And next,
Okay.
I would like to you to highlight to us another case, PT Wijaya, the decision of the Court of Appeal, which affirmed the doctrine of groups of companies. Can you please enlighten us on how it affects the corporate groups operating in Malaysia in the context of entering into an arbitration agreement? Particularly, many holding companies, subsidiary companies, all these concepts, right? So, yeah, please enlighten us in the context of this arbitration agreement. PT Vijay.
So in this case, there were two project management agreements. One was entered between the principals, being PT Wijaya, an Indonesian company, and Zikon, which is Sarawak Sarawak company. And then the second agreement was entered into by the nominees of the Indonesian party and the Sarawak entity called Zikon Construction. So then disputes arose between the parties. Both agreements had identical dispute resolution clauses, which said that the dispute shall be settled by arbitration. Now, the notice of arbitration was issued under the first agreement by PT Wijaya, basically the parent company, and the nominee company against the Sarawak parent and subsidiary Zikon Construction. The sole arbitrator issued a final award. Now, the High Court set aside the final award. It said that there was no single arbitration agreement between all four parties to refer disputes under PMSA 1 or PMSA 2 tribunal. Hence, there was no valid arbitration agreement within the definition of under the Arbitration Act. Now, the Court of Appeal considered the group of companies doctrine, deciding whether there was valid arbitration agreement. They allowed the appeal, they upheld the award. They said that the High Court erred when it held that there was no single arbitration agreement. They said that the second supplement, the PMSA 2, between the nominees was supplementary or collateral. It existed contemporaneously with the principal agreement. And then they also said both principals consented, assigned their contractual obligations under the primary agreement to the nominees. The aim was to facilitate the administration of the contract. And so therefore the Court of Appeal relied on this group of companies doctrine to hold that there was a binding arbitration agreement between all four parties. And so that's why they allowed the appeal. Now, the key principles and highlights of the case is that it's about this applicability of the doctrine of group of companies to arbitration agreements. Basically, arbitration agreements entered by companies might bind other entities in the group if actually the latter appears to be the true parties to the arbitration agreement. And because of their participation in either the negotiation or during the performance of the contract or during the termination of the contract, provided the court says that accords with the party's intention. And then the court highlighted the circumstances in which the doctrine can be invoked, the relationship between the parties, commonality of the subject matter, composite nature of the transaction, and group structure with strong organizational financial links, basically to constitute a single economic unit or single economic reality. Now, Ms. Tan, what I wanted to say about this is that yes, this position will definitely affect Malaysian companies in the sense that you may have situations where arbitration is being initiated against not just subsidiaries but parent companies and the like. Actually, this group of companies doctrine has not been embraced I think not in the UK, for example. In the UK, they still go back to whether or not you can lift the corporate veil, right? Whether the company was a facade, whether it was a charade, and they use those kind of principles to pierce, as it were, the corporate veil. So interesting. Let's see where this takes us, and whether or not this is developed further. Yeah.
Good.
So
Thank you.
that's PT Vijay. Yeah.
Thank you, Mr. Gwendran. So before I want to now move on to another topic, and before I pose my questions to you on the arbitrator power and procedural duty, and can you
Yeah.
please highlight to us the three
Yeah.
recent decisions in Telecom Malaysia, Kasugi Prima, and Enghan Engineering first? So after you highlight to us all these the three cases, the key takeaways from these three cases, then I will have certain questions that I prepared for you. Then you might then please enlighten us. So,
Sure.
Mr. Gandra, please. Telecom first. Yeah.
Okay. So basically, here there was an agreement between Omnet and Telecom for Metro Ethernet services, and that agreement has an arbitration clause. Disputes between the parties were referred to arbitration. The arbitration was bifurcated. Arbitration is it's quite common for arbitrations to be bifurcated. The arbitrator, usually it's between liability and quantum. It can also be bifurcated in terms of different issues, but usually it's between liability and quantum. Now, the arbitrator decided liability orally and refused to issue a written award until after quantum. Telecom filed an originating summons, they sought declaration that the oral decision was invalid and sought an injunction to restrain any further steps in the arbitration until a written award is issued. The High Court dismissed the originating summons, and that was affirmed by the Court of Appeal. The High Court held that nothing in the arbitration agreement compelled the arbitrator to publish a written award with respect only to liability, and the Arbitration Act gave the arbitrator discretion to conduct the arbitration in any manner he deemed fit. And the Court of Appeal affirmed the High Court's decision. And of course, it went up to the federal court. The key issue there was whether an oral decision given by an arbitrator is an award. The federal court allowed the appeal, set aside the Court of Appeal decision and the High Court decision. In doing so, the federal court referred to Section 2 in terms of the definition of award, which is a decision on substance of dispute. They also spoke about it in terms of final, interim, and partial awards, but not procedural and interlocutory orders. And then they looked at Section 33, which provides that awards shall be in writing stating reasons. So then they said liability is clearly part of the substance of dispute, and once it was decided, it was an award within Section 2 and 33, and held that the oral decision was invalid, no legal effect, and without valid decision liability, arbitrator could not proceed to quantum. So the key principles and highlights of this case was that the award must be in writing. The arbitrator's procedural discretion is not absolute. You always see arbitrators or counsel saying, "Oh, arbitrator masters procedure; he can do whatever he likes," but it's not absolute. It has to be. It cannot override statutory requirements under the Arbitration Act. And then to promote finality and enforceability of the award, liability determination is final. It is capable of enforcement and challenge, more importantly. So publication and furthermore, the publication of an award on liability is also necessary to ensure the tribunal is functus officio on the issue of liability. So that's the key principles and highlights of this case in terms of the award. Mr. San, shall I move on to the next two cases? Then
yeah, please. Move on to Kasugi.
Yeah. So in Kasugi, the facts here, I must disclose also that actually I was the counsel who did the arbitration. But I wasn't the counsel who did who brought the matter up in the High Court or the Court of Appeal. Anyway, Kasugi appointed co-brain for the Bank Rakyat project in KL. Disputes arose between the parties. A sole arbitrator issued an award. Now, this arbitrator invoked Section 21(3)(b) of the Arbitration Act, and she disregarded expert evidence, relied on her own knowledge and expertise. Now, just to highlight what Section 21(3)(b) says, it's just about powers conferred under the Arbitration Act would include the power to draw on the tribunal's own knowledge or expertise. So Kasugi sought to set aside the award and Kobayashi tried to enforce it. Now the High Court dismissed the setting aside and enforced the award. The High Court held that the arbitrator had properly relied on Section 21 and had not failed to provide parties with a fair and reasonable opportunity of presenting their cases. Up to the Court of Appeal dismissed the appeal. The key issues which were dealt with the Court of Appeal were whether this Section 21(b) was only invocable on procedure, not fact, substance, or merits, whether invocation was premature, and whether the invocation was breached of national justice. Now, I must explain a bit. Under Section 21(3)(b), it talks about procedure, and it talks about what happens when parties don't agree on procedure. So the argument run by counsel is, look, you cannot invoke all those powers which are given under the section unless firstly, it must be a matter of procedure. Secondly, parties must have failed to agree on this procedure, right? Unfortunately, the Court of Appeal was not persuaded by that argument. It says arbitration authority under 21(3)(b) is not limited to only determine matters of procedure, can be invoked to determine fact, substance, or merits. And the arbitrator is allowed to invoke that section, whether or not there is a disagreement as to procedure. But in this case, actually, at the end of the day, the Court of Appeal said actually no external evidence was used. The arbitrator had drawn upon her own expertise and knowledge to be applied as against the available evidence, and says this did not require arbitrator to give notification or opportunity to rebut parties. Now, these are the key issues. But I think I want to straight away jump into the next case, which then you will see a contrast. And what is interesting is, in this case, it's the same arbitrator. I won't mention the name. The same arbitrator in Kasugi was also involved in Heng Han Engineering. Now in Heng Han, the main contractor and who is Heng Han and Toshiba were the nominated subcontractors on a Sutra Avenue project in KK. And disputes arose between the parties. A sole arbitrator issued the award. Heng Han sought to set aside the award, and Toshiba applied to enforce the award. Now, the arbitrator dismissed the setting aside and enforced the award. The High Court dismissed the setting aside and enforced the award. It found that the arbitrator did not breach natural justice. She applied her mind to essential issues in the arbitration and said, therefore, the award was not contrary to public policy. Up to the Court of Appeal, the Court of Appeal allowed the appeal and set aside the award. The Court of Appeal looked at whether there was a breach of natural justice when the arbitrator considered two new matters, when the arbitrator relied on their own knowledge and expertise under 21(3)(b, and the award provided no reason for what's required under 33(3)(a). So first, the Court of Appeal said, arbitrator failed to give reasonable notice and reasonable opportunity to parties to submit on the two new matters which the arbitrator raised, and therefore it breached natural justice. She did not state that she relied on her. Now, strangely enough, then the Court of Appeal said she did not state that she relied on her own expertise in respect of two matters, so therefore she could not invoke 21(3)(b. Anyway, strange. That point is a bit strange. But then thirdly, they said if the award does not contain any reasons, it does not necessarily mean the tribunal has reached natural justice. Now, the key takeaways from this case is this, and the Court of Appeal referred to a Singapore decision and gave us three scenarios where there could be an argument whether or not there was a new matter raised where you had to give reasonable notice in order to do something. So the first scenario is where the tribunal answers a particular issue in a way so far removed from any position which parties adopted that neither party could have contemplated the result which the tribunal came up with. So that's the first situation. That would be a breach of natural justice. Second situation, the outcome of the arbitration was surprising to parties as they had not addressed the question the tribunal posed as being the decisive issue because they did not know and could not reasonably have expected that it would be an issue for. So that scenario, that's a breach of natural justice. The third scenario is where the tribunal decided on a premise which, though not directly raised by parties could reasonably have foreseen that issue would arise, or issues reasonably connected to an argument that parties have raised. Now that is not a breach of natural justice. Now I can give some examples of that, but maybe Mr. Tan, I'll give the examples
Yes.
when you ask me the question. Then the second point with the key takeaway for this is that it says that if the award does not contain reasons and there is a breach of 33.3, that in itself does not constitute proof that the award is in conflict with public policy. Breach of 33, which is the sections provides that the award must be in writing, must give reasons, does not necessarily mean the tribunal has breached natural justice. So basically, that's those three cases.
Yeah.
So your question.
I like your slides. Very clear. It's a
Yeah.
little digest. So yeah. So in these three cases, first that Mr. Gondran, in telecom, now premised on Section 33 of the Arbitration Act, then the Federal Court held that all kinds of awards, be it interim or final, must be in writing with reasons for its decision. Then in enhanced engineering, Court of Appeal, that it held that Arbitration Act does not require either expressly or by necessary implication an arbitral tribunal to set in the arbitral award expressly and in detail all the issues and evidence adduced in the arbitration proceedings. Now, Mr. Gwendran, can you please enlighten us on what constitutes a sufficiently reasoned award? Now, to me, this term may be construed subjectively or objectively, depending on how one may argue on it. Just like if I were to ask you, I were to ask my Tan Sri Chairman, Tan Sri David, on whether you are a sufficiently rich person or not, then you might immediately ask, the Tan Sri David might immediately ask me, hey, in what aspects? So you need, for those who think they are sufficiently rich persons, please send me a private message. So yeah, this is the thing.
Yeah.
What constitutes a sufficiently reasoned award? Please enlighten us.
So I think you had a first question. The first question was Telecom Malaysia. They said you must have reasons, right?
Yes.
And then Enghan says no need to have reasons, correct?
Does not require an arbitrator to set out in arbitral award expressly or in detail all the issues and evidence.
So the first thing is you must understand in telecom it was not an application to set aside an award. Enghan was an application to set aside an award, right? So Enghan Telecom, they didn't have to consider whether or not there was a breach of natural justice. In Enghan, they had to consider that. Right? I'll come to why I mentioned that. Because and there's still a debate about this. Simply because there are no reasons in an award does not mean that there's been a breach of natural justice. Because if you remember, you can only set aside an award for breach of natural justice, right? So even though you've breached the Arbitration Act, Section 33, Section 37 doesn't say that a breach of Section 33 means an award should be set aside. It doesn't say that. It says only if a breach of natural justice. So Enghan said, even if you don't have reasons, doesn't necessarily mean there's a breach of natural justice. So that's the first distinction. The next question is whether or not it should be a sufficiently reasoned award. Now, when I studied for my arbitration exams, and I'm tutoring as well. I always tell people about the acronym FLAC. I said your award must have FLAC. Facts, must state the facts, must state the law, must have an analysis, and must have a conclusion. So if you have all those things, then it would be, I think, an award which is reasoned. But if you do not have, I mean, if you just say, Mr. Tan said this and Tan Sri said that, I accept what Tan Sri says. That is not a reasoned award. You know what I mean?
Yeah.
Because why did you accept what Tan Sri said, right? Yeah, I think as well. So as long as you say why, it doesn't need to go into reams of pages as to why you think Tan Sri is wrong. So that's, I think, the answer to that question.
Yeah. Okay. Then, Mr. Gwendra, in Kasugi, the Court of Appeal echoed on Section 21, Subsection 3 of the Arbitration Act and held that an arbitrator may use his own expertise and experience to apply his mind upon the evidence presented for determination of facts, substance and merits and procedure. Now, what are the precautions to be taken by an arbitrator when he intends to draw his own knowledge and expertise? Can you please highlight that?
So I think this is a good opportunity to give you, those three scenarios which I think even in Engan, Justice Wong Kim Keong mentioned, right? So he gave three scenarios, and if you look at the case, he gave three examples. That case also got three examples now. So the first scenario, right, is a case where he says, if I may go to the scenarios, a minute.
The earliest slide, I think that was
So you see the three scenarios there. So the three scenario, the first scenario he gave this example. He says where one party was the issue was what was the law governing the governing law of the contract. One party said Singapore law, the other party said Chinese law, right? The tribunal in its decision decided that it was US law. Nobody argued, right? So it says, because you answered it in that way, nobody could have contemplated that result. So in that situation, definitely you must go back to the parties and say, hey, look, you are saying this, he's saying that, but I think it's this, right? Because nobody would have contemplated that result. So you should have gone back and given them that opportunity. The second scenario, and which is this, he gave another example, right? Says the outcome of the arbitration, surprising as they have not addressed the question the tribunal posed as being decisive issue because they could not reasonably expected that it would be an issue in all. That was a case where the issue was whether there was it had to do with the sufficient water in the port for the ship to dock. So one party says, look, this port didn't have sufficient water for the ship to dock. The other party said, oh, this port has sufficient water for the ship to dock. The arbitrator, in his decision, said, oh, I think the turning area in the port was unduly restrictive, and so the port was not safe. But nobody argued about the turning area in the port, right? So in those circumstances, you must give an opportunity. It's not that you cannot find that position, but you must give an opportunity for both parties to address you on it, right? So that was the second scenario. And very quickly, I have time, right? I have time. On the third scenario where it's not a breach of natural justice, he also gave an example. So one party argued that a clause was a condition. Going back to first year law school. The other party argued that clause was an innominate term, right? The arbitrator came out with a decision and said that clause is not a condition, or neither was it an innominate term. It was a warranty. Okay. So the court said, look, that decision could reasonably be foreseen by the parties, right? Although not directly raised by the parties, you could have foreseen it because one party says the condition, one party says the nominate term, but it could be other things as well, right? So it's reasonable to expect the tribunal to say, yeah, I don't agree that it's a condition, but I also don't agree it's a nominate term. I think it's a warranty, you know. So it's a bit of a thin line to be drawn, but that's how the courts have drawn the distinction between the three scenarios. I hope that helps explain when you're supposed to give an opportunity and when you're not supposed to give an opportunity.
Yeah, thank you, Mr. Gandran. I'll take that as advice. Yeah, my last question to you, based on your three cases that you analyzed for us. Now, this is more on the point on setting aside an award. Now, the statutory regime of the arbitration law in many countries, including Malaysia, detects minimal intervention by the court. We all know this. Now, court intervention is very limited to statutory grounds and must be restricted to exceptional instances such as lack of jurisdiction, the award is standard with fraud or corruption, breach of rules of natural justice, like just now we highlighted to us, and on the ground that the award is in conflict with the public policy of the country concerned. But of course, to me, public policy, these two big words, is too subjective, and maybe it's a separate topic to be talked about next time. Now, for today, I want you to highlight us, Mr. Kwendran, in order to avoid the arbitral award to be set aside on the ground of breach of rules of natural justice. Can you please enlighten us on this requirement for an arbitrator to give reasonable notice, reasonable opportunity to the parties when the arbitrator consider a new matter which was neither adduced in arbitration nor submitted by either party, yet this arbitrator want to consider it. Now, what is the advice to be given to this arbitrator? Can you please enlighten us?
Well, firstly, I think if it is, I mean, I think definitely if he wants to answer a particular issue, like in the first two scenarios, right? If he wants to come to that kind of conclusion, he definitely needs to go back to parties, because parties, there are two things parties can do. One is parties can say, hey, actually, nobody asked you to answer this question, right? So you come back to me and ask me this question. I don't think you have jurisdiction, right? They could say that. But they could also say, yes, I think it is an issue. It is within your jurisdiction because it is connected, right? And so then both of us will give you a response to it. I mean, I recently we had a matter where the tribunal, neither party raised the COVID Act. The tribunal on its own volition wanted to raise the COVID Act, and he did come on and say, look, I think the COVID Act is applicable. So neither party raised it, and we thought we checked the position. I mean, because it's a statute, maybe a point of law, it may be able. I mean, you may be able to raise it. So we didn't want to take the risk of saying you had no jurisdiction to rule on that. And we said, yes, okay, we will deal with it. But thank you. You came and gave us an opportunity to deal with it. Now imagine, right, if he had not told us this, both of us submitted, and then in his award, he comes and says, oh, anyway, all this thing, COVID Act makes all these decisions, right, unlawful, right? So quite clearly, we set aside for future natural justice.
So to summarize down, if let's say I face a busybody arbitrator like that, then I can say, hey, you don't prolong the proceedings. We are not asking you to decide on this issue. Right? Don't claim your expenses. Yeah. Okay. I mean, thank you so much, Mr. Quendron. Thank you for highlighting to us all these recent cases, which is all very practical. I mean, to me. And then before I think I move on to close it, and then of course now we open to the floor. Anyone, any questions to our two esteemed speakers who are so good? I'm so impressed. So please, is there anyone? From the chat box here, it's like nothing, because your two, Christine and Mr. Quendron, you're presenting maybe too clearly. Michelle, just to confirm with you, Michelle, is there anyone pose any question?
Yes, actually.
Oh, yes,
These,
not in
yeah,
the
these
chat box,
these
secretly
questions
to you,
are,
secretly.
yeah, it was sent secretly to me. Yeah,
Okay.
they wish to be kept anonymous. So I think
Yeah,
this
please.
question is in relation to Satya Awan. Is that where the Court of Appeal held that an optional clause becomes binding once a party elects arbitration. So is it still a good idea for practitioners to advise their clients to rely on multi-option or optional arbitration clauses in construction contracts?
Simple answer, no. So I think let's be clear. All right, if you think that this dispute ought to go to arbitration, then you ought to have it. You ought to make it clear that you only want to go to arbitration. Now, I must also tell you that you will see, especially in international contracts, and especially when it comes to financing, there are these clauses called asymmetrical arbitration clauses, and it's quite common in the financial world, where the lender has a right, the borrower does not. The lender has a right to either litigate or arbitrate, and the borrower does not have that right. The matter. And the reason for that is, of course, if the lender wants to go to a jurisdiction where he feels litigation may not be helpful to him, then he will choose arbitration, right? In an unfriendly, or maybe the borrower is from that jurisdiction, right? So the lender is not from that jurisdiction. So maybe he doesn't want to go to litigation. The other reason is because arbitration awards are impossible, and judgments may not be. So in the context of what we're saying, like Satya Awan, in the context of normal construction related contracts, I don't think you should have a optional clause. Just decide what you want to do. Yeah, just my answer.
Yeah, Christine, no, that is the Satya Awan is the case covered by Mr. Kohendran. Feel free to add anything you want to say.
Nothing to add. In fact, I was nodding rigorously to what Frederick has said.
Yeah,
It's
so happy
definitely
get
a
free
clear
legal
answer. Yeah.
Michelle, any more question from anyone?
Perhaps a follow-up question. This is my follow-up question,
feel
actually.
free.
So, you mentioned that if it's clear-cut, it's just a normal construction contract. It is, parties should decide what they want to do, whether it's litigation or arbitration. Then what do you think potentially is the rationale behind this specific case that they opted for an option clause in the first place? What is a good thing that they yeah.
I mean, yeah, I must ask the lawyer who drafted. These clauses, they're called the midnight clause for a particular reason, right? They are the last clauses. Nobody looks at this clause, right? When you sign a contract, you don't even look at the clause, right? So it's of no significance to you, so somebody may have drafted it and left it like that, and then this is the consequence. I don't think anybody really sat down, thought about it. If you did sit down and properly think about it, then it would not have been drafted in that fashion.
Yeah, why put themselves in such a position of uncertainty?
Yeah.
I think, yeah. So that goes to the drafter, the lawyer. The lawyer. Yeah. Okay. Yeah, anyone else, feel free. Until this hour 6:35, we still have our 30 participants, not bad.
Yeah, there's this question that should be Miss Christine's case, the ING Bank and the One Mega case.
Okay.
So basically, this is a comparison or between REJA and Arbitration Act. So what factors should counsel consider when deciding whether to enforce a foreign arbitral award in Malaysia via REJA or Arbitration Act? Is there like a specific checklist, like procedure, speed that counsel should consider?
Well, I must say the immediate answer would definitely be unfortunately, there's no checklist. It very much depends on a case-by-case basis. I hope this does not come across as like a lawyer cop-out answer, but it really truly boils down to the factual metrics of the matter. So I think the most basic of it would be to consider, is REJA even applicable? Because like we've gone through earlier, it only applies to the reciprocating country as spelled out in Schedule 1. And currently, I believe there's 7 reciprocating countries. So that's number 1. So if you don't fall under those lists, it goes out this option is not available to you. And perhaps also the most basic things also to consider, have you gotten, or rather have the party gotten a confirmation judgment? Because REJA can only come into play if there is a confirmation judgment by the seat country, the seat court. So there are all these factors for parties to consider, and as well as then you take into account, I think, circumstances of the matter, whether perhaps if you take one step further in terms of enforcement, then perhaps you must also then consider from the angle of what exactly is the objective of the enforcement. Is it to recover assets? Is it financial consideration? Where are the debtor's asset and financial status in different jurisdiction, assuming it's cross-border in nature? So there are different factors at play. So I don't think there's a straightforward checklist situation that could be applicable. Yeah, that's from me.
Yeah, thank you. Anything else, Michelle? Anyone? Otherwise, I have to do the closing remarks and then I go for
I think
dinner.
there's one last question. I put this question to the last because it's more general, not case specific. So, in your view, is Malaysian arbitration moving towards more flexibility, as seen in Setiawan and Katsugi, or towards a more stringent procedure requirement, as seen in Telecom and Enghan?
Mr. Gwendran.
So I think generally, looking at all these cases on balance, right? I think it favors arbitration, lah. So for example, like telecom, I mean, you cannot do what you do in sorry, Tan Sri, you cannot do what you do in court, lah. Oral decision, and after they come up with judgment, 6 months later, don't need to write also can. So it's a good thing, lah. In favor of arbitration. Yeah.
No worry. Arbitrator always will be motivated by the fees than to write. Yeah. Anything else, anyone?
That is all from the chat box. Yep.
Okay, I mean, just to do the very quick closing. So first of all, thank you so much to our esteemed panel, Mr. Kohendran, Ms. Christine, for their insightful comments. I'm so impressed, so happy. And I must emphasize on pro bono basis now. And then for providing an overview on the latest arbitration cases in Malaysia. Now, you see, in Singapore, the Singapore Academy of Law published an annual review of major arbitration cases. I think many of you are aware, covering a wide range of issues of law that arise in arbitral proceeding on yearly basis. Now, in Malaysia, I believe we are equally brave. We can produce a similar annual review of our key arbitration decisions, particularly from our appellate courts, in concise format with cross-references to certain relevant statutory provisions and commentary if necessary. So surely, like our well-established AISC under the leadership of our well-respected director, Dr. Mary Lim, all this, they can take on this leading role. Now, such publications would, to me, would greatly benefit all the stakeholders in our arbitration work and also enhance the quality and consistency of arbitration in Malaysia and ultimately help to elevate Malaysia's position as a preferred arbitral seat. Now we are losing so much to Singapore, but I think from time to time we can improve. Now for BicTok, we are now about 3 years old, and as an emerging ADR institution, indeed the only second one in Malaysia. Now BicTok is always working hard to promote arbitration and mediation in Malaysia as preferred methods of dispute resolution. As BicTok Council member, I would like to share that we will be publishing our second BicTok's bulletin very soon. Michelle, you can confirm on that, I believe. Now, we hope that this second bulletin from BicTok will help everyone stay updated on what is happening at BicTok, the latest developments in Malaysia arbitration scene, and of course, we will do our best to feature the most recent Malaysian arbitration cases in this second BicTok bulletin, including the cases that Mr. Kuhendran and Ms. Christine just now have so wonderfully enlightened us today. Now, once again, thank you to our esteemed panel and everyone who signed up for this BicTok and engaged in the Q&A section. Now, lastly, I would like to say have a wonderful rest of the evening. But of course, last but not least, please always remember to support BicTok on all the events that we organize. Then we come to share and learn and develop together for the benefits of all the stakeholders in the ADR. So thank you, Mr. Kuhendra, Ms. Christine,
Thank you, Mr. Tan.
Michelle,
Thank
for
you.
all the coordination. Thank you, everyone.
And thank you, Michelle. Thank you, Mr. Tan.
Thank you.
Bye.
Thank you.
Bye.